Good afternoon, everybody. My name is John Dornberger, and I'm a lawyer with the law firm of Post and Schell. Welcome, everyone, to today's construction law webinar, which is being presented by EHD Insurance and the law firm of Post and Schell as a service to our clients and other industry participants. Today's topic is the Pennsylvania State Construction Notices Directory, and this is something that was born under the Pennsylvania Mechanics Lien Law, and it became effective in 2017. We've put together today's session to discuss the rules of the road with respect to the Construction Notices Directory, because while it went into enactment in 2017, it's been our experience that many industry participants are just really learning about the directory, because as we'll discuss in the coming hour, projects do not have to be registered on the directory, and at its infancy, many were not. But as time goes by, many are. In this hour, we'll take you through the rules of the road about the directory, which the notices directory, we'll just refer to it as the directory. We're going to tell you what it is. Then we're going to tell you why it was created. More importantly, we're going to give you checklists. As an industry participant, whether you're an owner on this webinar, whether you're a GC on this webinar, or a sub, or even a second tier or supplier, we're going to try to give you some practical checklists at the end so that you know what the directory is and what you have to do if your project is registered on the directory. More importantly, we're going to go through some issues that we see as crucial requirements and deadlines that project participants might miss if the project is registered on the directory. So we're hoping that your takeaway from this is to have notes to make sure if your project's on the directory, you don't miss anything that you're required to do to either prevent a lien or to protect your rights to a lien. Presenting me with today is my fellow partner and principal, Ryan Logan. Ryan and I are with Post and Schell. Folks, we have a mid-Atlantic construction practice. So our group at Post and Schell is devoted exclusively to the commercial construction industry. So we span from the Carolinas up to New York. I'm resident in Harrisburg. Ryan's actually resident in Wilmington. But in this day and age, we're everywhere. And we practice throughout the state of Pennsylvania. Today's webinar focuses only on Pennsylvania law, only on the Pennsylvania Mechanics Lien, and only on the Construction Notices Directory, which is born within an amendment to the Mechanics Lien Law. I'd like to introduce you to Kyle Weimer at EHD Insurance. They are also a host and presenter, or I should say a participant and presenter today in the webinar. EHD Insurance has a deep bench in the commercial and other construction practice area, and I'll let Ryan speak about their services and capabilities.
Yeah, and thank you very much for having us and the opportunity to sponsor this today. Like you said, I'm our construction practice group leader within our firm here, and we work alongside a lot of law firms, but just like you guys with Post and Schell, other carriers, industry partners, to make sure that you're protected from the top to bottom. So you, as a construction company, you can go out and build and do what you do best. And we always like to say we're not just insurance brokers, we're risk advisors, advocates, and we're a part of your extended team. And we work through that, whether it's navigating these liens, bonding contracts, or whatever they are. We're working through you through contracts to support it and make sure that your business is protected and protect the assets that you guys have. So we appreciate being here today. If you ever have any questions, don't hesitate to ask us. We're always here to help and looking forward to it.
Thanks, Kyle. Okay, so we're going to talk about the notices directory today, folks. And I want to touch on the Mechanics Lien Law generally, because this is where the directory came about. So back in 1963, Pennsylvania passed its Mechanics Lien statute. And what it did is it provided you folks who build, whether you're a general or sub, it provided you folks with the ability to file a lien against the property itself. And so one thing that we always forget, and it always happens, quite frankly, is clients forget that you have a contract which has payment terms. And if you're not getting paid under that contract, you proceed under the contract to court or to arbitration, whichever it says, to get paid. But the mechanics lien law allows you to attach your claim to the actual owner's property that you perform the improvements upon. And it is widely believed, and we lawyers do know it to be, somewhat of a better leverage to getting you paid, because other than a construction contract claim, when you have a claim against the property, you can put something in front of the owner to raise and elevate your non-payment issue. So a mechanics lien goes against the property. It's filed in court. It's not filed against the parties, but it's filed in court. And next slide, if you would. There had been kind of some, what I'll say, decentralization and confusion about mechanics liens, which I'll get into in a minute, for a number of years, which necessitated the legislature, through some lobbying efforts, and as I understand it from the general contractors lobby, they pushed for the construction notices directory. And for one reason, this is one place, this is one website that every project participant can go to and look at and see what's happening on a project with respect to subcontractors who are performing work if they register. I'll tell you what that means in a minute. If the project's registered and they file a notice of furnishing, and we'll tell you what that means in a minute. But it's a single place for all project participants to just go on a website, review, and see what's happening, and it's free. So this was part of an amendment in 2014. Doesn't matter to you. What matters to you is it became effective in 2017. And it created this online centralized directory for projects. And their projects over $1.5 million. And I'll give you some particulars on that in a minute. So what's in it? What's in it are mandatory filing requirements to both register the project, but then when do you register? Then requirements for you subcontractors to make sure you file something that protects your rights, not to waive your lien, and protects your lien rights. Don't worry, we're going to spoon feed you all these deadlines and requirements throughout this hour, okay? But that's what it is. It's got mandatory filing requirements. So and think of this directory as you owners, you GCs, it's kind of a shield for liens. And you subcontractors out there, it's kind of a sword for you to make sure you don't lose your lien rights. As a general rule, you subcontractors out there, you can't waive your lien rights until you get paid. If you sign a payment app or sign a payment lien waiver, you lose your lien rights. But you can't waive. It's policy, Pennsylvania law. You can't waive it. But this directory has a gotcha in it, okay? If you don't do something under this directory, if the project's registered, you can waive your lien rights. Don't worry, we're going to tell you how not to do it. Next slide, if you would. So the problems leading up to this was you're a project, you're on a GC on a project. It's a $5 to $10 million project. You've got what, like 12 subs, right? And if those subs are going to lien your owner's property, each one of those liens is filed separately in the courthouse. You have no one place to go look at. It's all decentralized. However, with the directory, with projects registered there, both the owner and the GC file the project as registered, and then the subs file a notice of furnishing saying we're on the site, we're working. And it gives everybody visibility as to who's working on the site to the extent they comply with the rules of the road, which we'll go over today. As I understand it, the government relations people and the lobbyists who pushed for the directory with the General Assembly, it was really the general contractors and the owners really wanting to know what subs are out there. And the owners wanted to know, when I pay my GC, who has and has not been paid. So they didn't want to learn at the end of the project. So it gives them a little bit of an early warning. Next slide, please. So the purpose, again, is increased transparency. Let all project participants look in one place for this. Allow the owners to look at assess their payment risks. And it really encourages and kind of takes some business away from us lawyers, which is great for you, bad for us. But the point being that a lot of disputes and lien claims are either cut off by what happens in the directory or permitted by what happens in the directory. So it clarifies some things. And it modernizes it, right? No more sending your super out to tag on a lien posting notice on the side of your trailer, you know, you do it at your desk, right? It's modernized, it's an online system. Next, please. So here's where it is. So we'll show you some screen snippets from the site in a moment, but here is your centralized one location website address. So DGS, the state, administers this site, and of course it's this single location, and everybody, owner, GC, sub, everybody on this call, you all go to this one place for your project, both to register it and then the effect after registration of what all you folks have to do after that, which we'll tell you in a moment, all happens within this one website. Let's go to the next one, Bri. What projects are covered? McMansions are not covered. Single family homes are not, even over $1.5 million. This is really designed for commercial projects with a general prime contract of $1.5 million or more. That's what it falls under. I know I see many of the participants who signed up for this call. This is the space you're in. You're doing commercial projects $1.5 million over. But should you happen to be doing multifamily, it doesn't apply to a single family home, and it would apply to multifamily with more than 4 units. So that's what this is about. Next slide, please. Here's what we're going to talk about today. These are the 5 things that you need to either make sure you know have been filed or have been filed and complied with under the directory. So first is the registration of the project, putting it onto the directory, step 1. Who does that? Either the owner or the GC. You GCs out there on this call, I know some of you, your owners are requiring you to file it as their agent, right? And that document's called a notice of commencement, or an NOC. That starts the ball rolling. So the owner's building, you know, an office building, and they say, we want this project on the directory. In their prime contract, they usually require you, the GC, to do all the dirty work, right? For you to go on the website and register the project. So that's the first thing. We'll go through all the rules on the NOC. Next is the notice of furnishing. This is a reaction to the notice of commencement. You subs out there, once you see that the project's on the directory and registered, you have a time limit to file your notice of furnishing. The one thing I want everyone to take away from today, the big issue with the directory is you got 45 days, subs, to file your notice of furnishing. And we'll tell you exactly when that starts and when it ends. But that's the big issue, whether or not the sub filed a notice of furnishing. And why not? You'll lose your lien rights, okay? So we don't want you to lose your lien rights if you're a sub. Then there's some other forms out there. There's a notice of completion. Owners and GCs can go in there after substantial completion and file a notice of completion. And that'll tell the subs that filed that the project's over from that standpoint, because you subs don't necessarily have visibility to date of substantial completion with your general, and that may trigger your retention release. So it provides some visibility for the subs in that regard. And then there's a notice of non-payment. You subs can file something to say, hey, owner, I haven't been paid. It doesn't affect a claim or anything, but it certainly gets the owner with the ability to take notice that you haven't been paid. So those are the 4 things you file on the site. The 5th thing, which we're going to spoon feed to you today, is what notice provisions do I need to put in my prime contract, my subcontract, and any second tier contracts. So we'll go over those today. Next slide, please. This is what it looks like on the site. So this is, Ryan, this is exactly the snippet from the site, correct?
Correct. Yep.
All right. So this is door number 1, door number 2, door number 3, door number 4. You go on as an owner or GC, you're clicking notice of commencement, and we'll show you what the form looks like in a minute. You go on, you register the project, and we'll show you what gets kicked out. That's on there. Project's on the directory, right? Next door number 2 is notice of furnishing. That's you, the sub. You're saying, hey, I'm working on this project, and I'm here, and I'm protecting my lien rights, and I'm on the job. The next 2 are optional. The top 2 are required. The last 2, notice of completion, is substantial completion to give everybody notice on the project that it's happened. That's optional. Subs, your owner and GC do not have to file that on the directory. They may do it, but they don't have to do it. GCs, just make note, your owners may require you to under contract. So make a little mental note there. Gosh, I got to look at my prime contract to see if my owner is requiring me to file a notice of completion on the directory. I haven't seen that yet, by the way, in a prime contract. So, but I can envision it. And then the notice of non-payment. Okay, Ryan, let's go to the next one. I think what you're going to do is talk everybody through the notice of commencement in the particulars of what everybody has to do.
Yep. Yeah. So first, just wanted to say thank you. Like John mentioned, I work with John at Post and Schell. We're both in the construction group. So we appreciate your time during this presentation. So the first thing, like John said, and kind of the big ticket that kicks off everything is this notice of commencement. As John mentioned, it's filed either by the owner or the GC. And actually, as you'll see on the next slide, it says owner's agent. So in some instances, we've actually seen an architect file this occasionally. Not saying that that's the typical, but it's defined as owner's agent is able to file it. So this must be filed before or when work begins. And that's really when the prime contract work begins. It includes kind of your general information you might expect. The project name, probably taken from the prime contract, the owners and the general contractor's information, and the property's location. Once it's submitted, it's listed on the directory and it becomes searchable. So all of the subs can go in, and actually anyone can go into the directory and look to see if a project has been registered. There's actually been some news articles about some development that have been picked up, and that's just because this is a public directory. Nothing on the directory is necessarily private. And then, like John said, you general contractors out there may be required to file this. And it is actually kind of self-explanatory once you get in. So the first thing you're going to see when you click on that notice of commencement button is, are you the project owner or are you the project owner's agent? Once you click on whichever one you are, it asks to fill in the information about the project itself, like I mentioned before, and this is actually what it spits out. Now, this isn't the clearest, but I just wanted to highlight some of this information that's relevant to what you have to do and what you have to tell your subs and otherwise. So the first thing is at the very top, there's a notice of commencement ID. This is just established by the directory, and that's what is going to be used to identify the project on the directory itself. Now, the project is also searchable by project name, and it's actually searchable by owner name and contractor name. But the commencement ID, I want to highlight that because you have to provide that, and this has to be posted on the site by the owner and or the GC. So all of this information, so if you just print this and post it, that's in compliance with the act. So as you can see at the top, there's the searchable project owner. Like I said, that's the owner. The project detail. The one thing to flag in here, because it's relevant for mechanics liens, is the parcel tax ID number. This is where people have to list what the property is. As John mentioned, mechanics liens attached to the property. So by listing the property tax ID, that's telling the subs and actually the general contractor, this is the property that's being developed. Once you type in all of that, the terms and conditions are automatically generated. You don't have a choice as to what they say. They come up, and there's two things, one of which I already mentioned that are key. The first is that you post the notice of commencement with the ID on the property. That has to be posted somewhere, so maybe on the trailer on site or otherwise. The other key thing is that it says in these terms and conditions, you have to take reasonable efforts to make the notice of commencement part of the contract. So in some ways it doesn't make sense because you don't necessarily have the notice of commencement if the GC is filing it, but it requires that at least there's mention and or reference to it. And we actually have, as John said, an exemplar for owners to insert into their prime contracts that is compliant with this. So owners look out for this, GCs look out for this as well. So once the notice of commencement is filed, this triggers the reaction of subs, sub-subs, and suppliers. So that reaction is this notice of furnishing. Only subcontractors and sub-subs, which would include suppliers, manufacturers and whatnot, have to file this, but only if a notice of commencement is filed. So even if pay attention to your contract. It may say a notice of commencement was filed, but if you search the directory and it's not, that may be a question you need to raise and flag for, your general contractor to say, was this ever actually registered? Because if not, that does not trigger your responsibility to file a notice of furnishing because there's nothing to file it to. The notice of furnishing is the response. And when you have to file it is within 45 days of either you first provide labor/work or materials. So general contractors out there, owners out there, this could mean, and usually does, that not all subcontractors have to file at the same time. So a plumbing subcontractor may file separately to a site contractor or a concrete supplier. So keeping track and knowing when your subs are coming on to the site and or even when the sub-subs are coming on is going to be very relevant. And the key thing of this whole filing is the notice of furnishing is what preserves your lien right. If you fail to file this, the statutes say you waive your ability to lien. Doesn't waive any other contract remedies, but your mechanics lien is potentially at least waived. So what does this look like on the site? Well, you select either you're the subcontractor or the representative of a subcontractor. I'll be honest, I've never dealt with someone who is a representative of a subcontractor. It's typically the subcontractors themselves that are filing it. You go through, you insert your information, you insert the project's information, and I wanted to highlight the furnishing detail because, as many of you already know, in mechanics liens, you have to identify the work that you're performing and or the materials you're providing. So this doesn't have to be exhaustive. It's probably something out of your contract, but you do have to describe when or what type of work you're doing, and as you'll see, when you started that work, because that's what triggered the 45 days. So you have to say, I'm starting on this date and or I started on this date. So you can file it early, but you have to file it within 45 days of starting work. Once you go through and type in all the information, it spits out this. The notice of furnishing is given its own ID number. It then identifies all the searchable information that's from the notice of commencement, but it also then identifies the hiring entity. So if you're a sub, it'll identify the GC. If you're a sub-sub, it'll identify the subcontractor, and then the subcontractor itself, which is the actual person filing it. Then after that, you have a description of the materials and labor. Like I said, this is what usually gets plugged into the mechanics lien itself to describe the work. It's a requirement in the mechanics lien claim. Therefore, they made it a requirement here. After that, you'll see the 2, that's to the owner. Then please take notice that, labor is being furnished to, and that'll list the general contractor. Under that, we'll list the property. And then it'll say, and I know it's hard to read, it says the labor, work, or materials was first started on, and it'll list that date. That's going to be the date that triggered the notice of furnishing. Much like the notice of commencement, there's terms and conditions that are automatically generated when you file. Nothing really critical in there. It's essentially you're saying, I acknowledge that I'm required to file this within 45 days of performing work at the job or providing materials. So it's not so much a verification, it's just that I'm complying with the statute, I'm complying with the law. And then so that this is tagged and kind of lumped together with the notice of commencement for that specific project, it then lists the notice of commencement ID and the notice of furnishing ID in one spot so that if you're searching, if someone else is searching, it comes up there. The legal description at the bottom, that's the legal description of the property itself, which is taken from the notice of commencement. So those two, the notice of commencement and the notice of furnishing, are, as John said, the required filings, the initial and the reaction. The next two that I'm going to talk about are the optionals. The first is the notice of completion, which John mentioned. This is purely informational. It does not impact whether anyone has or retains their lien rights. It's just putting notice out there that substantial completion has been attained. And in some cases, like John said, we expect to probably see this become a requirement so that owners know and or maybe try to trigger a response for a notice of non-payment to see where things stand and what risk they have. The second is, again, the notice of non-payment. This is filed by the subs and suppliers, just notifying both the owner, the GC, and others who are attached to the project, others who have filed notices of furnishing, to say, I haven't been paid. Maybe you haven't been paid. So those four, the notice of commencement, of furnishing, completion, and of non-payment, those are what you can file on the directory. They show up under the project itself, and it's a single repository for all that information. This next slide that you'll see, this is what you must insert into a contract. The statute, for whatever reason, did not say this shows up on the directory, but says this needs to be incorporated into at least a subcontractor's contract with the general contractor and then downstream. Our recommendation is the owner should have it in the prime contract as well, so that there's a flow down to all the others. But as you'll see, and as you can read, it says failing to file the notice of furnishing may forfeit the right to file a mechanics lien. That's the big thing. That's the difference between where the mechanics lien law was before and where it is now. There's now something that can actually establish a forfeiture of your rights to file a mechanics lien. So I'll turn it over to John for a hypothetical that we've actually had to deal with about what happens if this provision isn't incorporated downstream.
So, yeah, thanks. I wish this weren't a real situation, but it is, in that I think while the General Assembly was well intentioned, both the mechanics lien law itself and the amendment with the directory rules don't necessarily provide the best and clearest guidance. So there can be mud out there, and the muddy areas are what happens with sub-tiers, second tier subcontractors. On projects that are registered, the owner puts the contract clause Ryan just showed you into the contract. A GC then takes out all of its A401s, all of its subcontracts, and it puts that clause in all of its subcontracts. But what happens if the first tier sub doesn't put that contract provision in the second tier's subcontract? We have this situation where we have a second tier filed a lien and we're trying to strike it on a case that's registered. And what we did is I represent the GC. We pulled out the subcontract and it's in there, right? But our second tier, our first tier sub, our prime sub didn't put it in the second tier subcontract. So that guy's saying he's from, I forget it, he's from like Arizona or something. He's a material supplier. He's saying, I didn't get this. So I didn't know it was registered, so my lien rights are preserved. He files a lien. Is he precluded from filing the lien? I know you clients hate this, but I'm going to tell you, we don't know yet because the statute's not clear enough. Go to the next slide if you would. And here, by the way, just because this is a muddy area, we're going to tell you how to avoid it. You're going to know by the end of this hour how to avoid it. But here's the situations we run into with these things. The statute says contracts have to have that notice, which we gave you on slide number 20. You guys all get the PowerPoint later, so you'll have all of this. So it says the contract has to have it, but it doesn't define contract. So when you're a GC and you're kind of screaming at your sub, hey, you didn't include this clause in your subcontract, the statute doesn't necessarily say that's required. Okay, so how do we make sure it gets into all downstream contracts? Because while I think that we're going to prevail in our case, the issue is the mechanics lien law, it gets decided by judges in county courthouses. They don't go to federal court. It goes to a local, county courthouse. And sometimes the argument is that, the law is meant to be all-inclusive and to provide relief and protect those who perform work on properties. And some judge out there could say, hey, if the statute doesn't define contract, I'm going to let this guy file his lien. So one of the things we're working on, well, what if the subcontractor knew the project was registered? Okay, the second tier didn't have anything in its subcontract, but what if it knew? Because that's how to attack this. But even beyond that, we're going to give you a contract cure to show you how to take care of this issue if you're a GC or a first tier sub. Next slide, if you would.
Yeah, so so before we kind of get to that, as we've already mentioned, this is a lot of repetitive stuff, but everything is online. There's nothing that is paper anymore. What you do is you go in and you create an account. I actually created an account. There's no real restriction on it, so that's why I was saying a lot of people can go in and search for things and look at things. Now, if you want to just search, the searching is free. You don't need an account. To file something is when you need an account. And then, as I said, the forms all have the same information that's required. Now, just to kind of hit the nail on the head of important things, there are those key deadlines that we've mentioned, but we wanted it in one place. And the first is that you have the contract notice provision. This is included in the contract before execution. Prime contracts may require the GC to include it in their subs. GC may require that the subs include it downstream. That's what the hypothetical John just mentioned and talked about is attempting to avoiding the situation where somewhere downstream, someone says, I didn't get that contract notice, therefore I had no obligation here to file anything. So the notice of commencement, just to reiterate, it must be filed at least before or when work begins. Typically, it's filed before, either by the owner or the GC. Notice of furnishing by a sub or second tier sub within 45 days of first providing labor, work, material. What we've seen and what we've recommended is once you sign a subcontract, even if you're weeks out, you can file the notice of furnishing. That's just the end date. 45 days is when you start. You can file it early, but you can't file it late. And then just so we don't forget, the overarching lien itself must be filed within 6 months of the last day of work. That's unchanged. This directory does not change the actual lien claim requirements. It just adds further hoops you need to jump through. And we'll talk about
Subs
that.
have 5 months. Subs have 5 months, remember, because
Well,
they got to give notice.
yeah, so and that's what I was so we have a slide about a checklist. Subs need to send a notice that's at least 30 days prior to that 6 month deadline. So there's a checklist at the end that you'll go through that can kind of that follows where you want to be and what you want to make sure you're following. So what are some of these practical implications? Owners, they must ensure that it's registered and that there's that posting, like I mentioned, on the site. Has to be somewhere so that someone can see it. There's a little snippet in there that says if it gets torn down, you have to take reasonable efforts to put it back up. It's a requirement that it remains throughout the entirety of the project. At the same time, the delegation downstream to make sure that everyone is in compliance, make your GC do things, GC make your subs and and then so on and so forth. For contractors, what's the practical implications? Here, you still have your lien claim must be filed within 6 months. You're also likely going to be responsible for downstream compliance, education, making sure it's all incorporated, and honestly, probably tracking to see when these notices of furnishings are filed because you're probably the ones who are going to know what the subs are doing and when. Subs, suppliers, track the dates that you need to file the notice of furnishing. You have 45 days. And like John was saying, you have 6 months to file the lien, but 30 days prior to that, you need to send a notice of intention to file a lien. So subs have an extra step when actually trying to file their lien claim. But the notice of furnishing, if it's registered, if you miss that, it doesn't matter if you file your lien claim, it can get kicked for that reason.
All right, where can you go wrong? Here's a couple of 3 or 4 things. First, you're an owner and you're a GC and you file your notice of commencement. This is number 2 on this list. You file your notice of commencement after you started work, after work under the prime contract began. You're giving a subcontractor an argument that your notice of commencement is defective and they can still lien even if they didn't file a notice of furnishing. Number 1 on that list, you're a sub, right? You didn't file within 45 days of the date you started your work. So you missed the deadline. Another common pitfall is not checking to see if a project's registered because if, let's say you're even a subcontractor or a second tier, And you're doing big projects, you're doing projects, multi-million dollar commercial projects, even if your subcontract doesn't have that value, the project does. So it's a good practice to check just to see if the project is registered by searching and querying the address, the contractor's name, the owner's name. And then failing to put in the contract requirements, meaning UGCs, failing for you to put the notice in your subcontracts. Use subcontracts, failing to put the notice in your second tier subcontracts or your purchase orders with material suppliers, which I know gets arduous. We can talk about that as a practical matter. Next one, if you would.
Yeah. So let's I was gonna say, so let's start with I'm an owner. What do I do? Where can I go wrong? So like John said, there's very common pitfalls, but this we think is very specific to what the owner needs to do. First, include the provision in your prime that it is a project on the directory, that it's going to be registered. You want it to be registered. Now remember, the threshold is 1.5 million. So there are going to be some projects that just don't qualify. If you want your GC to register it, include that provision in your contract and make sure that you also require them to tell their subs and sub-subs, hey, you need to put this in your contracts so that the notice of furnishings are filed and so you don't get into that situation where someone doesn't file but says, I didn't know. If you want to register it yourself, register it before work begins. But even then, incorporate into your prime contract that the GC must make sure the notices are all into downstream contracts. Then throughout the project, you're gonna be monitoring it, especially at the 45-day, after work begins to see where the notice of furnishings are or not, so you can assess your lien risk. As I mentioned, these can be different throughout the project. The specific subs have certain deadlines based upon their own specific work. So this is a monitoring throughout the project just to see who has filed, who has complied, and where things stand. And then, as always, just a little plug for ourselves, call your lawyer if you have any questions. Now, as we mentioned, so this is an exemplar just for discussion purposes as to what can be inserted into the prime contract. I will say that half of this is the exact notice that's taken from the statute, and it starts about midway down where a subcontractor that fails. But this is something that can be put into a prime contract to notify the GC and or for them to then incorporate downstream that says, this is registered on the directory, here's the notice of commencement, and or a notice of commencement will be filed and will be provided. Then it goes on to say, to preserve your rights, you must file a notice of furnishing within 45 days, and then it actually provides them with the state notices directory website. We believe that having all of this information, while not specific to the statute, at least covers you for the argument that, oh, I didn't know where to go, I didn't know anything about this. This at least would cover, the notices downstream, especially as it flows up, because the owner, who's likely the owner of the property, is going to be the one who's going to be tagged with a mechanics lien down the road.
Thanks, Ryan. So let's turn to your GC. I know many of you on the call today are GCs. So you guys, from a project management standpoint, you guys are checklist queens and kings, right? I know that. So one of the best practices we suggest to general contractors is just incorporate a check on the directory in all of your pre-commencement of work checklists. One of the things you should be checking, is this thing registered on the directory or not? And then, of course, in your prime contract, you should know if it's registered. The owner should have that notice in there. And then the next question is, hey, do I have to put this notice in my subcontracts? The owner, best practice, whether or not the owner requires you to put the notice in your subcontracts. Because remember, contract's not defined under the statute. So we don't know if it's required. But whether or not that owner says, hey, GC, you must put this contract notice in your subcontracts, do it anyway. If the project's on the directory, do it anyway. So you'll include that in your subcontract. And the third bullet point here is really important because this is what I'm tangling with right now in a court in Pennsylvania. Tell your sub you must put the notice in your second tier subcontracts. So put that in your subcontract. Tell the second tier, you've got to put this notice in. And then it's a contractual obligation at that point. So what do you get there? You get a little protection because if a second tier files a lien, you at least have a contract action against your subcontractor because they didn't put the language and the notice in their sub agreement. And then the same advice as the owners: monitor the directory, to see when notice of furnishings were filed after work was performed. Next slide. This is the same exemplar for UGCs that Ryan showed you for the owners, but you can just copy this same thing. You'll see something in substantially the same form in your prime contract. You can just grab it and put it right into your subcontracts. Next slide. All right, I'm a subcontractor. What do I do? Well, you're the one who can lose your lien rights. So you already know that you got to file either before you start work on a project on the directory, or you got to file within 45 days of starting work before you turn into a pumpkin. So check to see if your subcontract has the notice provision. And belt and suspenders, if it doesn't, check the directory anyway. Just check the directory, even if you see nothing in the subcontract that they sent over to you. If they missed it, file the notice of furnishing anyway. It's a belt and suspenders. It protects you. It doesn't cost you anything. For projects that are registered, we recommend that all of you subcontractors grab that contract notice, the same provision we showed you on slide 30, grab that and put it into your second tier subcontracts and require them, they have notice, and require them to give notice to their third tier and other material suppliers. And so we think that the best practice for subcontractors is to put this on your same checklist that the GC might have to make sure you don't miss your 45-day deadline. Next one. So this is the same. We've repeated this slide, guys, but it's on slide 30, and I think it's 29. Now it's on 32. You'll have this in the PowerPoint, which we'll send to all participants. And this is the provision that you can put in your second tier subcontracts, providing them the requisite notice. All right, next one. I think this is you, Ryan.
Yeah. So lest we forget, as we've been mentioning, the directory is great, but you still have to comply with the rest of the mechanics lien statute. So we just wanted to provide this little checklist and refresher. So there's a difference between a contractor and a subcontractor. The mechanics lien law actually just defines a contractor as someone who has a direct contract with the property owner. That's it. If you don't have a direct contract with the property owner, you're not a contractor under the mechanics lien law. So contractors have it a little bit easier. They have 6 months after the last day of work or completion of work to file their mechanics lien claim. So once you finish, put it, on your calendar. I have 6 months from now, if I'm not fully paid, to file my mechanics lien. Once it's then filed, you must ensure that it's served properly within 30 days. And properly is actually key. Pennsylvania has very specific service requirements in the various counties that actually say mechanics liens must be served by a sheriff. There's one county, and it's at least one, common is Philadelphia, which says a process server can serve it. And or if it can't be served, you can post it. You can post it on the property, but the sheriff must attempt to serve it first within 30 days, and it must be served. After that, you must then file an affidavit of service within 20 days after it's been served. So you have 30 days to serve it, 20 days to file an affidavit of service. As an aside, there's actually a recent case that actually went through and said that a notice and or affidavit filed by the sheriff counts as an affidavit of service as filed by the liener, the person filing the lien, but belts and suspenders, filing a separate affidavit of service is probably the best way to go. Obviously contact your attorneys if you have any questions and or utilize them, but I wanted to flag those sort of service requirements because they are mandatory. And if you miss them, you can get your lien stricken from the record. Subcontractors, basically the same thing, except as John mentioned and I mentioned before, at least 30 days prior to filing your claim, you have to send a notice of intention to file a lien claim. And as a subcontractor, because generally you're the ones who have filed the notice of furnishing, you have to say that you complied with the notice of furnishing and provide all of that information. So contractors generally don't, they're the ones that either filed the notice of commencement or know about it, but they didn't have to file a notice of furnishing. Subcontractors had to file the notice of furnishing. So as part of your lien claim, you now have to say you complied with the provisions related to the directory. And then once it's filed, you follow the same procedure as it relates to service.
Okay, so again, participants today, we will be emailing you with a copy of the PowerPoint slides so that you'll have some of the forms we put up here. But the takeaway is your procurement folks, when you're handling your contracts, you have to have at the ready contract provisions to the extent you're doing work on a project that's registered on the directory. We've given you some exemplars today. If you have any questions, let us know. Incorporate the internal deadlines in your other diary and tickler systems as a project manager. Make sure that you're watching your deadlines. And the big deadline for the GC is to get that notice of commencement filed before a shovel goes in the ground, before work begins under the general contract. That's not pre-general contract work. That's your work under the general contract. And then use subcontractors to make sure you get it filed no later than 45 days after you hit the site and start your work. So create internal deadlines from a project management standpoint. Then owners and GCs more likely than subs to monitor the notices directory generally. So I looked at the one project that I'm working on that matter with a second tier filing a lien, and we're trying to get it stricken. I looked on the directory and I know there's like 15 subs on that project, only 2 filed notice of furnishings. That's it. So all of the subs had a contract notice in their subcontractors from the GC that this project was on the directory. Now this goes back to 2018, so it was only 1 year after enactment. So I understand that there was a lack of information out there and people didn't have a lot of education. But like a year or two after the directory came through, even people who saw the notices directory language in their subcontracts didn't go ahead and file their notice of furnishing. And then track the dates for the filing the mechanics lien, same project management discipline. After you've finished work, put 6 months in your diary system. Subs, after you finish work, put 5 months in your diary system. Next slide. And so here's where our citations are. Again, this is the directory website link. I don't expect you to read the statute, but the statutory authority is the mechanics lien. And the Department of General Services, they administer the notices directory. I'm hesitant to even tell you to go ask them questions about the notices directory because I don't know if they're ever going to answer them. But ostensibly, that's where you go with what I'll say technical and other questions with respect to your filings on the system itself. So thank you all for participating today. Our endeavor was to try to give you the rules of the road and then kind of give you some concrete documents and information to take back to your projects to use if your project's on the directory. But we probably have created some questions out there for some of you. And you don't have to ask them now. You can if you want. You don't have to ask them now. You'll get the PowerPoint slide. If you don't have my email address or Ryan's, it's on there. Send us an email. We'll answer any follow-up questions. We hope this has been helpful. I will tell you that if you're one of those people that know a fairly decent amount about the directory right now, good for you. If you're one of those people that don't know much or didn't know much about it until today, you're not alone. You're not alone. We're getting calls all the time by really good, well-established prime subs, mechanical subs, other really good companies, and they just weren't there yet. And it's because maybe they have a small handful of their projects on the directory and not any others. But my sense is that lenders might push owners to require this, and we're going to see this directory registration as a requirement on more commercial projects, driven, I think, frankly, by the lenders and the funders of the projects. Thank you.
Thank you.
I don't see any open questions, so we appreciate everyone's participation. Kyle, thank you very much.
Thank you. We much appreciate it.
All right, take care, everybody, and have a great day.
Thank you all.